Welcome to Baker's channel where stories unfold, covering trials, dramas untold. Grab your seat, settle in, start the show. Courtroom clashes, the fun we bestow. Baker's channel, action's hot, dramas and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Lawyers smart, tensions high, sparks fly. We laugh, we learn, dive into the why. Join the chat, have your say, it's your place too. Every twist, we're here for you. Baker's channel, action's hot, trials and fun, all we got. Discuss, debate, break it down. Baker's channel, just the best in town. Join the crowd. Baker's channel, we're live and loud.
Good morning, good evening, good afternoon, wherever you are, whoever you are, what if any you are. And for those of you who haven't noticed, I've changed the description because I didn't know that Sarah was having a hearing today. So we're going to cover the hearing, not the last 58 pages of her prison inmate notes. That will be tomorrow. I just sat in a meeting with some very boring people, so I have to be honest, I don't feel up to reading for 2 hours. But hopefully, you'll still stick around because we will now see if a lawyer can be as great as Sarah Boone, straight A student, excels at everything. I think it's a downgrade that she went with a lawyer. I still think pro se would have been better for her chances to get acquitted. Well, it's a good day, just a boring meeting, especially because that meeting ended with, well, I really don't know anything about it. I'm getting someone else to call you tomorrow. Ricola. We are live. DB. Oh, it's a good thing Jamie isn't here. She would be crying. But I'm sorry. Hey, Spacey Stacy. And Helen from Holland. And Nunya, mom of 10. Chantes Inferno. Would have been entertaining for sure. I'm going to sue her for that $1 million if I don't make that million she promised. But today is a hearing. Remember, she got her new lawyer. The new lawyer asked for a continuance just so they could get into if there would be a battered spouse defense possible. And I haven't watched, I saw bits and pieces of it, but I'm really interested in if the judge keeps the same hotline he had the entire time, said, nope, you had enough time. This has gone on for 3.5 years. It's because of Sarah we haven't gone to court yet. So if you watched it, probably with Mo, wonderful coverage as always, make sure not to spoil it for those of us who hadn't gotten all the great stuff. Well, I'm going to sue her for damages. Well, yesterday I got on the horn with the provider, and in Denmark, because we are a wonderful socialist country, one company has the monopoly on all fiber, and then you can buy the fiber access from different companies, but it's still one company that makes sure everything works on it. They had made an update, and everything related to Google, YouTube is a Google product, was bad. I had an 800 download rate and a 90 to 160 upload rate that just fluctuated. So it didn't come back till I think 2.5 hours after I ended my stream. Baker, I was on Mo earlier, but that was after she finished her coverage. My third video from Spain is now available. It's from the Molino Water Park. Everyone, when we're done, go check out Fedorowski's Spain adventure. Amish people have better internet than I did. Yes, but they don't live in a socialist paradise. Well, everyone who has anything to do with Google was hampered yesterday. And I don't know, but I don't use any. I use Chrome as a search tool and everything. Yeah, it's just Google based. Hey, Sully. And Jatsira. Squabby. One gifted membership to Spacey Stacy. Thank you, Squabba. But I'm interested to see how this lawyer is doing it in court. And I'm really interested in seeing if having a lawyer changes the judge or he'll still be a hard ass and say, I gave you all the warnings. You have to fit into my schedule. It's Zero Sum with a new name thanks to a kid who thinks he's funny. Well, Knita, no. Knita, whoa. I like Zero Sum better. But let's do it to it, as the kids say. Boom, 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 boom. Come on. I could have prepared this.
Oh. Sir, hang on 1 second. I'm waiting for the state. Thank you for your patience. Thanks.
Hey, Amika. Come on. This is amazing. There she is. There's my girl. There's my girl. Look at her. Look at that smug face. That little that's for me. I bet you that was for me. Let's do that again. Sarah knows she's free. She sent me a little smoochy smooch. Be still, my yearning heart. Sarah gave me a smoochie. She's gonna make me a millionaire because she knows that I'm gonna move to the United States, and she's gonna buy a suitcase, and we're gonna move in together. And Marissa will cover that trial. Oh. Did you all see it? She's so hot. Yeah. You thought I was done. This is the comeback. Hey, KDP. I am a lucky boy. Oh, just for me. This made my day. Now Jamie can yell at me all afternoon and I'll still be happy. Look how happy she is. She's smiling. She knows she's off the hook. Oh, I'm looking at you, honey boo boo. I'm looking at you. Give daddy a little smoochie again. Come on. You know what that is. Give him-
Judge, I'm James Owens, and I'm representing Sarah Boone.
Sir, good morning. Pleasure. Ms. Boone, good morning. Could you please state your, raise your right hand now. First, going to go ahead and swear you in.
Do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes.
Ma'am, good morning. Could you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
Good morning, everyone. We are here on several different items. The first is the court's notice of hearing that was sent out last week. The first issue on that was addressing the view.
She would just say, I brought you cheesecake, and I would say, just get the suitcase out. You don't have to force me. If I can stay away from the cheesecake, I'll jump in there. Well, you saw it today, and it was beautiful. Well, that time when she come running out of her house when Jorge was arrested, and she said, oh, the cops are here. She smiled back then, too. Why the heck is she smiling? Because I'm watching her. Yes, that smug face, and I don't know who she's sending air kisses to, if it's to her lawyer or her PI, but she thinks that this lawyer is gonna get her off the hook. If she gets acquitted, Baker will be jumping every time he hears a knock on the door. Shouldn't have offered that, Dr. Pepper. Probably shouldn't have. You're right. Oh, we're going to read that part tomorrow, Crystal. But yes, she has a lot, and I like a cheeseburger. Baker plus Sarah equals 4 and 20 Baker parts all in a pie. But, and I like my my pause game is good too today. She's the 20-year-older Hack 2A girl. The only problem would be you would have to look at her face, and you probably wouldn't be able to enjoy anything Hack 2A related.
Viewing of the physical evidence here in open court.
Oh, look at that hand motion. Look at that hand motion. I just said the Hack 2A girl.
Addressing the viewing of the physical evidence here in open court on.
One says she's asking for a pen. No, it's subliminal. It's me.
Including the viewing of the digital evidence no later than September 3, and the physical evidence viewing you take here.
Iris, I just want to disclose it now. Sarah is sending me subliminal messages. She blew me an air kiss, and then she made this motion. You know what it is. Well, let's see how well he's doing. Your kids wanted to chat now and behind. Probably don't have your kids when I'm in this mood.
Place here in open court on September the 3rd, and a schedule for objections thereafter. The digital evidence review took place on August 9th, and the August 23rd deadline for objections has since passed. On August 14th, the court was advised of an alternative arrangement and advised the state to file a notice reflecting when and where and how that review would have taken place. I did not receive.
No, I'm super happy. Sarah gave me an air kiss.
Receive such a notice in a court file. Mr. Cashore?
Yes, Your Honor. We were not able to file the notice prior to today. However, on Friday, August the 30th, we were able to have that evidence review of the physical items with Ms. Boone at the Orange County Jail.
Okay, all right. Ms. Boone, can you confirm if in fact that viewing took place?
It took place.
Okay, all right, very good. And who did it take place between the state, yourself, and was Mr. Lane with Prison Break Investigations a part of that viewing?
Correct.
Okay, all right, thank you very much. Also set for hearing this morning was defendants.
An air kiss. She blew me a kiss. And then she made a Hack 2A motion to me.
motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense that was filed.
I think her hands are still cuffed now because she's not. She's in the box. I don't know. Do we call it the pen or whatever, where they put defendants? Because she's not her lawyer now. If she had been at her table being pro se, she would have been uncuffed.
14th. The next day, August 15th, JSCS filed a response to the motions for payment of costs and appointment of a neuropsychiatrist. Paragraph 10 of the JSC's response reflects that JSC will not be participating in this hearing. Mr. Owens, good morning. What is your position, sir, with regard to Ms. Boone's pro se motion for costs? Are you adopting that motion?
I'd like to abandon that one, but substitute it in for two other motions for the appointment of a forensic psychologist, Dr. Julie Harper, who was on this case previously. I believe she saw Sarah Boone about 6 times at the Orange County Jail. She was working under the direction of the original counsel, Mr. Padilla, who I believe had the case for about 2.5 years. And I think it was set for trial, ready to go, and then at the last minute he withdrew. I tried to call him a couple of times, haven't been able to find out what went on. I have talked to Ms. Cashman, the last lawyer, but we don't need.
No, Michelle, we are just, this is the first motion. Well, he had a motion, he withdrew that motion and then filed 2 more because he wants an original forensic psychiatrist back on the case who saw Sarah 6 times. But I believe, didn't they skip her because she didn't say what Sarah wanted her to say or something like that? I believe I read that somewhere, but we'll figure it out. Hey, Wales. This is her new lawyer. Yes, the guy who had the website with her. I've been to trial 100 times.
This neuropsychologist that Ms. Boone had requested, but we do need a reappointment of the forensic psychologist, Dr. Julie Harper. I've spoken with her a couple of times last week. I text messaged her 4 or 5 times this weekend. She is in agreement to handle the case, to reopen her file. She has sent me her records. I have reviewed them. I've met with my client. I think my client meets the criteria for that spouse. I believe Dr. Harper, after she gets a chance to re-engage with my client, spend some time with my client, and hopes that she's going to be of that opinion. In addition, I believe it's necessary for the appointment of a crime scene reconstructionist and death investigator, Dr. Michael Berkland, who is from my area, Pensacola, is who I am recommending to be appointed.
What was his name again, sir? I'm sorry.
Michael Berkland. I followed these judges yesterday or last night. I don't know if they're in the court file yet.
I did not see them this morning. I did see the motion to dismiss.
Can I approach them in?
Yes. State, have you seen them?
No, his pictures is at least 10 years old in that on that website. It's too early for all this smack talk. It's 17 minutes past 6 o'clock, so no better time to do it. And when Sarah starts out by doing the little smoochy smooch to me, you know, this isn't because I have a stand desk. It's something else. You figure it out.
I just saw them briefly this morning prior to the hearing.
Thank you. The only thing I saw in the court file, counsel, when I was prepping last night was the motion for statement of particulars, the column September 2. I have not yet seen.
No, because she will be in her prison uniform. More interesting, is her prison uniform stapled to make it fit better?
These motions.
Judge, I also filed a motion for additional discovery. I don't know if that was that made it through as well.
Was that also filed yesterday, sir, sometime in the evening?
It was filed at 8:30 yesterday morning.
So I have a motion for statement of particulars filed at 8:10 yesterday, but I do not have the motion for additional discovery filed at 8:34.
I don't know why the court was not able to post that, because they were filed one right after the other.
One's in the court file, and the other's three aren't.
This is what the
They were all filed yesterday, 19.
certain things auto-populate and certain things have to be accepted.
Okay.
The statement of particulars and the additional discovery were filed yesterday morning. The motion to appoint the crime scene reconstructionist and death investigator and the motion to appoint the forensic psychologist was filed at 6:10 p.m.
I do see that. As the court previously identified, JCS chose not to participate in this morning's hearing by virtue of their response filed on August 15th. They're not here. Your motions for these various experts report that they were sent to all persons on the service list through the e-portal. But I don't know how I can address these this morning without having JCS.
Jeepers. Yeah, sometimes you wished we could cover trials in the same way. I know the translation part could be a little bit of a problem, but imagine getting some pictures from a trial like that, and we could just discuss it. That's the bad part about we don't do this, because people think it's only America that's crazy, but we have the same problems. We had 4 guys today who was on trial for, they claim self-defense. They are on surveillance video in a mosque, chasing a guy down some stairs, stabulating him, hitting him with a shovel and a rake, and they claim self-defense. I can't remember how many times he was stabulated, but it was quite a few. So we are cray-cray as well. It's not just Florida. Hey, tis Billy. Always shaves one's hands before going to prison. Oh, head. Oh, head. I was thinking hand. That doesn't make sense. Sarah's gonna beat the rap. She's innocent and she's a genius litigator and legal analyst. Someday her statue will be in front of every town hall in America. Yes, I think it was a mistake to bring in a lawyer. Sarah had this. This is just it's a waste of time. Sarah could have done better.
Here. So I will endeavor to coordinate a hearing for these as soon as practical. I understand these need to be addressed. Be advised, this is a trial week for the court, as is next week, but I will do my best to endeavor to try to get these heard as soon as possible.
Judge, and I filed my notice of appearance on Friday,
Yes,
and I've spoken with Dr. Berklin 2 or 3 times this weekend. The state was able to provide me with some discovery. I think once I filed my notice early Friday morning, I think the state provided a lot of discovery to me. I provided that to Dr. Berklin. I believe he has the autopsy. We cannot find the autopsy photographs, which he says are critical. We cannot find the crime scene photographs, which he says are critical to his evaluation. So I know time is of the essence. We've got people working on it, but there is some additional evidence that we need.
State, what's the status of the provision of the autopsy photographs and the crime scene photographs and provided to the council?
We provided all of those things previously, obviously, to the defendant, which has been greatly discussed already. When
They are discussing evidence that he claims he didn't get the autopsy photos. So, and now the state is going to say, well, we already did that. But so far, he seems like he's a little behind all of it. I don't know why. I just get that feeling. He's a little, Hey, Ada K, thank you for sending your peeps to me. And they can get a second doses of this, but not as good as they got it over on your channel. But thank you so much for thinking about little old me. And did you notice in the beginning, those air kisses Sarah blew, those were from me. Yeah. Me and Sarah sitting in a tree. Kisgging.
And Mr. Owens' notice of appearance came on the case. I instructed my assistant to go ahead and send copies of the document discovery, which is easily available to him, just so that he could quickly have that and not have to worry about getting that from his client or whatever. I believe we also sent notice to as well that if he wants additional copies of the autopsy and crime scene photos or any other pieces of digital evidence in the case, that he just needs to provide USB and he can go ahead and burn that for him. Again, this is in addition to what's already been provided to the defendant in this case.
Didn't she say in the beginning that they had a viewing of all the evidence and now it's not there?
Okay, do we have a time frame where we might be able to get that information to him?
If he wants to come back to my office, we can do it this morning / this afternoon.
Is your
Office in the building?
Yes, it's in the courthouse.
right there? Come out front door, make a left.
Okay. I don't have a USB with me, but I'll find one. This morning, we'll get that done.
Okay, I appreciate you both. With regard to the motion for additional discovery filed yesterday, September 2, 8:34 a.m., state you the opportunity to review this.
I just reviewed it just now here in court this morning. The state was going to request an opportunity to respond to both this.
She actually believes her lawyer is winning. She believes this guy is making sense. Sarah, dear, I don't think it's going to end that well. Yeah, because she's not a lawyer today. She's just a defendant today. So she's back in the pen with her handcuffs on.
Motion and also the motion to the statement of particulars formally and in writing, given the lack of time we've had to prepare to make a quick formal response.
Sure. And how much time, counselor, would you like in order to file papers?
Who is she smugly looking at, grinning at? Has she picked up a prison boyfriend? Is Tom Gillis in Florida? She looks like she's in love with someone with those little side eyes. Sarah, you better not be cheating on me. I do have a suitcase.
Response to the motion for statement of particulars and the motion for additional discovery.
I would ask for at least a week.
Any objection?
No objection.
Okay, all right. The state.
No, because she's looking off camera. It looks like she's looking below and to the right of the camera. Yeah, this lawyer will be gone before trial. I'm pretty sure of that.
Shall file a response to both the motion for statement of particulars and motion for additional discovery no later than the close of business 5 p.m. on Tuesday, September the 10th. And if hearings are necessary, we'll coordinate those. With regard to the defendant's pro se motion for payment of costs and appointing neuropsychologists to assist the defendant in preparation of the defense, the court's going to deny that as moot based on Mr. Owens' representation. With regard to the motion to appoint crime scene reconstructionist and death investigator and motion to appoint forensic psychologist, state, are you intending on filing a response to these?
No, we're going to take no position on those points.
Okay, all right. I will have Ms. Barrios, I'll ask the clerk to see if we can push these through the portal today so that Ms. Barrios can reach out to JICS and see if we can get a time frame on when they may be able to provide a position statement or a response to those motions, and then we'll coordinate a hearing respectfully.
Judge, I'm going to want to add.
Thank you, Squad Bob, for the gifted membership to None Your Business. Well, it is my business because it's my channel it's gifted on. Is it her lawyer she's looking at? Maybe. Yeah, now we need to see a white shot to see who she's looking at. Hey, Christine.
One other forensic psychologist make a request. I want to make sure that there's not an issue about my client Sarah Boone and I manufacturing defense. And there's a second doctor, Dr. Michael Brandon. I don't spell that right, sir. Dr. Michael Brandon.
B-R-A-N-N-E-N?
He spells it B-R-A-N-N-O-N. He was the forensic psychologist in the Marcia Thompson case. That was the Palm Beach County first-degree murder where she shot and killed her husband, shot him 9 times. He was laying on the couch and was acquitted of first-degree murder back in July of this year. That was a 2019 case, so that took a while to get to trial. But Dr. Brandon testified that a battered woman's experiences affect her perception of imminent danger. And that's going to be a question in this case, whether or not Sarah Boone, at the time of her actions, was facing imminent danger. In addition, Dr. Brandon said victims of repeat violence may fear death in situations others would not.
And
I've tried to reach out to Mr. Brandon this weekend unsuccessfully. And my intent is to reach out to him. I'm hoping he's going to respond. He claims on his website that he responds within 48 hours.
Marissa, or what would you use? Josephine, can any of you find that Marcia Thompson case, if you can find an article, just so I can read what that was about, because I can only find videos about it.
I will be, that's the only other witness I'm going to need an appointment for a forensic psychologist. So 2 forensic psychologists, Dr. Julie Harper, Dr. Michael Brandon, and then the crime.
Yes, I had that interview, but I got that strike or that warning because of the Corey Richards trial. So I'm a little shifty about showing news coverage because that could potentially give me a 7-day in the cold. So I'm not going to show that one, but maybe Jess will put in the link in the description so all of you can go watch it yourself.
Scene reconstructionist, Dr. Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator on the case.
That's the guy. It's Billy Lang, the investigator. Look at her when he says that.
Michael Burke. And then in addition, I would like Billy Lane, who's seated in the audience. He is the investigator.
Some PI has been dipping his pee in. So she's banging her private investigator.
On the case, because of the claims that we're making that she's a battered woman, we need evidence to corroborate that. So there's a lot of history between her and Mr. Torres involving the apartment complex, which is in Winter Park. That was 4 years ago. The ownership of that apartment complex has changed hands, so it's going to be somewhat problematic trying to get information about who all the tenants were that may have witnessed some of the violence involved in these 2, as well as we're trying to get together the 911 calls that Sarah made and others made about the disturbances between that couple.
Crystal, I said the same thing in my 2-hour conversation with the YouTube support, and they said, yeah, we don't care. So I'll have to write 90 days with that warning. I have been in contact with Megan Fox, but I don't know what, because YouTube said, yeah, it's against the law that they gave you, or that they claimed ownership, but we don't care. which is a misuse of YouTube's TOS. But if I had done it, I would be in trouble. When they do it, it'll be fine.
So he's got a lot of work to do as it relates to running down witnesses. In addition, we're trying to get arrest reports of the prior domestic violence arrest of Mr. Torres, as well as the officers involved and their body cams to see if there's any evidence on the body cams that would show injuries to Ms. Boone. So we've got a lot of work to do, but I believe it's necessary.
She's banging the PI, allegedly, in Minecraft.
For us to prove a viable defense of battered spouse syndrome, that we have cooperation. It's going to take a little bit, but I do need the appointment of that expert. He tells me he's already on. I'm going to have to file something else because it was under Sarah Boone. Now, as the attorney of record, I'm going to have to file something. He says he's still got plenty of hours to work under that original cap. So I'll be filing something today or tomorrow as it relates to that. But that's the only other. Of course, I've been retained, so I'm not going to make any claims for attorney's fees. I'm not making any claims for travel costs, just for these witnesses.
The JCS has already approved, I believe, $10,000 in investigation fees and $1,000 for other costs associated with Mr. Lane. That was at one of our previous hearings. Now, that was when Ms. Boone was representing herself pro se. I can't imagine JCS may change their position with regard to those costs.
No. He didn't say he was pro bono. He said he didn't want anything from the state. But in the interview after, he says she's paying him, which she can't do because she was awarded money as an indigent. So it must be, I don't know how she can set up. Can you, as an indigent, set up a I'm going to pay you later plan? Did she pledge his attorney fees? It's going to be interesting to see. Yeah, I love this judge. He's great.
They've already said yes, but file it and we'll try to tee it up for hearing as well to see if they have any position, or it can just be, the order can be modified to extend to you as counsel for Ms. Boone.
Thank you.
All right. That takes us now then to your motion for continuance file that was filed on August 30th. Courts had the opportunity to review that motion. Any other arguments or statements with regard to that motion? Mr. Robbins.
Judge, I reviewed the state case law relating to continuances and the palpable abuse of discretion when the court does not grant it. But it is critical to my theory, our theory of defense, battered spouse syndrome. And as you know, that takes time to develop. Especially when the motion basically speaks for itself, but we're in a time crunch. Essentially, the trial is set for October the 7th. I have to provide a notice of intent to rely on battered spouse syndrome 30 days prior, which is September 7th, which falls on a Saturday, so I believe that gives me till the next business day, Monday, September 9th. But still.
Well, he is smart because he is going to be a regular on court TV after this one. And he's going to get the book deal. I don't know anything. I don't know this guy. He's probably the best attorney in all of Florida. But he saw dollar signs just because he allegedly saw a lot of crime tubers on YouTube. He could see some are doing really good numbers on this case. So he probably thought, maybe I can either start a career, I can be the new Kurt Legalwise's mindset, whoever, a lawyer with a YouTube channel, because now I'm famous, or maybe I can do like Better Row and just go on shows and get to talk about cases. The only problem is he doesn't seem like he has the charm of any of these people. Even though I just at disclosure, Mark Betterow has the same exact shoes as every cop in Canton. Just saying. I'm not confirming. He might be a mole from the Canton PD. He still has hair, but he has the same shoes like everyone else.
6 days for Dr. Julie Harper to
yeah, but you're retired, so you couldn't do it anyway.
Come back out and visit with Ms. Boone, coupled with this other potential forensic psychologist, Dr. Michael Brandon, he's not going to have time to do that. They've got to establish a rapport with her before they can run the testing, spend the time with her. And it involves some extensive history. Obviously, that couple was together for 3 or 4 years. I still haven't peeled back all the layers. I've tried to go through it, but as you know, something like that is going to involve several instances of domestic violence that did not involve law enforcement. That was just between the two. So we've been going through that. We're trying to get some medical records where she was stabbed by Mr. Torres in the leg, and some other evidence. It's just going to take some time, coupled with the fact that I've got to get Mr. Lane to get all this other objective evidence, witnesses, and not.
It was a joke. It's just because he put a picture on Twitter today that he's wearing those same brown shoes that every cop in Canton had on when Matthew Farrell was arraigned. So I'm thinking, so I just made the joke he's an undercover cop. And yeah, imagine having Kurt, who is a very emotional guy, have to deal with this woman. Whew.
Calls and arrest reports, and provide that to the 2 forensic psychologists for them to help formulate their opinion as to whether.
Yes, her attorney is the one doing the meeting. That's why she's sleeping in the pen right now.
She is, in fact, that is found. In good faith, I believe she qualifies based on my spending 3.5 hours with her Labor Day, yesterday, as well as the other 4 times that I've met with her. I have not spoken to Mr. Cordelia, but I believe that was probably going to be where he was going to go. I was not, involved. I don't believe you were involved at that time. I may have been.
Not me.
Okay.
My predecessor was.
But I think it was always ready to go. And for whatever reason, he withdrew at the last moment. And then here we are. But I think it's prejudicial if we're not allowed to present the defense that we believe we have.
Don't go there.
And I would respectfully ask.
She went through 8 lawyers.
I think most times you come on a homicide case, you would need at least 6 months. I'm asking for 1 trial cycle, 2 trial cycles sometime at the end of the year or first of next year. I can be ready. I think that will give enough time for our experts to visit with Ms. Boone and formulate their opinions. I'm sure the state's going to want to take a deposition. I think they may have a right to hire their own forensic expert to go out and interview to see if they agree. But that's just going to take a little bit of time, Judge. I'm thinking 2 or 3 months, and we'll be ready to go. I'm not asking for a long continuance. The good thing about it is Mr. Cordelia has done a lot of the work. My understanding he's taken just about all the depositions. I believe they've been transcribed. I haven't gone through all the discovery. She's got the 2 banker's boxes. She has not gone through all the discovery. We tried, but we have not made it. My understanding is a lot of the 2-hour interrogation with the Sheriff's Department has been transcribed. They haven't reviewed that, but we do have a problem with that interrogation. Now, that's why I made the request about the policy. Our policy in my county, Santa Rosa County, is a little bit different. And based on my discussions with her, we feel like I'm going to need to file some motions relating to that. So, because of that, but ultimately because
they already went down the battered spouse, and I believe there wasn't really anything there, and that's why the lawyer quit. I don't know, but I think that's why he all of a sudden didn't want to pursue that. So it's a Hail Mary. It's always fun to throw a Hail Mary in the end of a football game, but this is like the Ohio State versus Dallas Cowboys. Dallas Cowboys have no chance.
yes, could I be ready for trial on October 7th? I believe I could, but not without the battered spouse defense, because I don't believe my experts would be ready. And so that's instrumental in our defense.
State, do you have any position?
I guess the state would just respond to a few things. Part of this battered spouse defense has been previously investigated with several of Ms. Boone's previous attorneys, and in fact, the state did retain an expert, Dr. Tanya Warner, who's on the state's witness list in this case, in anticipation of a potential rebuttal of an attempted battered spouse defense. The state's position would be that we would oppose a continuance at this time. However, the state's not opposed to setting another status hearing sometime next week possibly, where we could address this and to see if there has been any movement, anything that would either change the state's position or potentially the court's position as well.
I don't think the state's thinking it through, Judge, because if we wait a week, I've got to file a notice of intent to rely on battered spouse on Monday. We can't wait a week that the time has expired if the judge doesn't continue it today. He wants to have a conference next week, but it's too late for him.
What's your response to the rule requiring these battered spouse or battered wife syndrome defense 30 days prior to trial?
You have to give it.
Right, but I mean, clearly when that rule was created, it contemplated that there would be sufficient time to prepare for that defense within 30 days of trial, which is why they gave 30 days, which is why the Florida Supreme Court said that 30 days, not 60, not 90, not 120.
But in good faith, you can't file a notice of intent to rely on the defense of battered spouse syndrome if you don't have a supporting psychiatrist, forensic psychiatrist, that makes that claim. I just can't say, hey, I'm going to rely on it, and I'm putting you on notice.
No, I don't know where you get hundreds and thousands of court money. She has $15,000 to split between her previous lawyers. She has $5,000 for the forensic part and $10,000 for the PI. This lawyer will not be paid by the state. He claims he's being paid by her, which I don't know how the rules are, but she was indigent before he came along. So I don't know how he can claim he's getting paid unless it's on the pay-as-you-can man plan. So she's not, the only hundreds and thousands of dollars is the money we're going to waste on a trial. But the 6th and the 14th Amendment, even if you are the biggest POS, you are still a citizen in America, and the 6th and the 14th will grant you a trial.
I got to have some kind of authority. I'm not an expert. I think she meets the criteria, but I'm not a psychiatrist. I'm not a psychologist. I can't make that opinion. I've got to have an opinion from an expert before I can follow that in good faith. I can't do it without Dr. Harper. She needs more time.
Oh, it was Melissa Crawford who got the membership. Sorry, Squad Bob. Thank you so much.
Dr. Brandon needs more time.
All right, thank you. State anything else?
No.
All right, thank you very much. All right, Mr. Oaks, it seems like you've already started diving into the case and what the court file has reflected. So clearly you've reviewed what is in the court file and the history of this case.
Yes.
I'm sure you've read the court's June 28th order, which was extensive as to the history of this case, multiple lawyers that Ms. Boone has gone through, the reasons for the non-conflicted out lawyers' basis for withdrawal, and why the court ultimately made a decision that Ms. Boone had forfeited her right to court-appointed counsel by her actions, or alternatively waived her right to court-appointed counsel by virtue of her actions. This case has been pending for some time. You advised in your motion to continue that you met with Ms. Boone on 4 different occasions, that you just met with her yesterday for 2.5 hours. You were aware of what the order identified, which was in paragraph 6 of the order in the judge portion, that trial specially set for October 7th, 2024, and that it would be not continued for any reason, absent extraordinary.
Yes, but there's an interview out there where he says she's paying him.
Good cause, and such extraordinarily good cause would not include the retention of counsel. You haven't been appointed in this case. When you undertook this assignment knowing that you were not being appointed, and that by your own representation you're doing this free of charge on a pro bono basis and not seeking recompensation for any lodging or travel. You knew what the deadlines were for the court. With regard to any of the experts, there have been multiple prior experts in this case. You already identified Dr. Julie Harper, a forensic psychologist. You advised that she's met with the defendant on 6 different occasions. She was appointed back on August 3 of 2020 under Mr. Padilla's representation of Ms. Boone. At no point in time did Mr. Padilla file a Category A witness list disclosing Ms. Dr. Harper as a testifying expert, and as you astutely pointed out, this matter was days, if not weeks, away from being tried when Mr. Padilla moved to withdraw based on the reasons outlined in the court's June 28th order. Thereafter, Dr. Charles Heller, another forensic psychologist, was appointed on February 3rd, 2022, and again on March 1, 2022. No Category A witness list was ever disclosed with regard to Mr. Heller. Then Winston Hobson had an undisclosed expert that had met with Ms. Boone, as addressed in open court on February 9, 2024. And as Mr. Hobson put it, that expert was not meeting with what Ms. Boone had desired or requested of that expert. There was another expert psychologist that was appointed by Patricia Cashman on February 28, 2024, who has expertise in battered spouse and or battered wife syndrome. There were also Dr. Linda Dore, 2 times sought to be appointed, once by Attorney Bankowitz. Dr. Dore specializes in battered wife or battered spouse syndrome. Once by Dr. Bankowitz Mr. Bankowitz, on July 17, 2023, again by Attorney Hobson on January 1, 2024. Based on the Florida Supreme Court decisions in Middleton versus State, 220 Southern 3rd 1152 and 1176, Barber v. State, 221 Southern 3rd 562 at 569, there's a 2-part test determining the need of experts. We're not going to be addressing that today, as you sought to file these other motions that I haven't had really the opportunity to address. And JCS is not here to have the opportunity to review those.
Right now, I need a Morgan Freeman voice saying, and this is when the lawyer knew he effed up.
Versus State, 75 Southern 3rd, 1277, and pinpoint 1281 by the Florida 4th DCA in 2011, citing to Lawson v.
Ruth, we talked about this on another stream. There's no way you can get a limp body into a suitcase. Especially, he did it, and I think when he was just in there, the devil came over Sarah. She didn't make him unconscious or anything. They were probably playing some kind of weird game we will never understand. And when he was in there, then the devil took her.
State 84 Southern 2nd 540, also by the Florida 4th DCA in 2004. In that case, defendant Ramos changed his defense counsel at least 4 times while this case was pending, with the latest change of counsel occurring 2 to 3 months before the actual trial date. There's no record evidence showing that any of Ramos's previous attorneys had provided ineffective assistance, and the defense had already moved for 4 continuances to prepare for trial. Similar to the Ramos case, Ms. Boone has played a prominent role in shortening the preparation time for trial, as set forth in the court's June 28th order. This case has already been continued 16 times. As of the date of your filing of your notice of appearance on August 30th, this case has been pending for 4 years, 6 months, and 4 days. On June 7th, this case was...
He asked to have it continuance to mid next year, late next year, so they could get experts in on it. And the lawyer is just, the judge is just reading, this expert has already examined Sarah. This has been continued 16 times. This lawyer now knows this judge ain't no pushover.
Specifically set for trial on October 7th, and the June 28th order by the court specifically speaks for itself and evidences how Ms. Boone played a prominent role in shortening the time for preparation for trial when her 8th attorney, Ms. Cashman, withdrew. Ms. Boone reached the point where her right to adequate time for preparation and trial was counterbalanced by the right to the effective administration of justice. As of August 30th, when the notice of appearance was filed, there were 37 days until trial commencing in this matter. Considering the prejudice of the denial, Ms. Boone has already availed herself to 4 different attorneys that were not conflicted out, Padilla, Bankwitz, Hobson, and Cashman, and only has herself to blame for the withdrawal of those 4 attorneys based on the representations in those motions and the findings in the court's June 28th order. Discovery has been reviewed with Ms. Boone by prior counsels, as established by counsel's representations in various hearings, and prior counsel's motions for attorney's fees, all of which were filed in the month of August of 2024. Ms. Boone has had discovery in her possession since August 5, 2024. The digital discovery that the state seeks to admit at trial was provided to Ms. Boone on August 9. Although you are not court appointed, sir, the court's done its own research with regard to your expertise. You've been barred since October 15, 1986. With a duly elected public defender of the First Judicial Circuit in the state of Florida from 2009 to 2012. You've tried over 100 cases to verdict throughout your career. You've met with Ms. Boone on 4 occasions, as outlined in your motion, not including the meeting that you had with Ms. Boone yesterday. As to the battered spouse syndrome defense, you still have time to file the appropriate notice in accordance with the rule. And considering all the factors as set forth in terms of the state 311 7 3rd 185 and 189, 42nd BC of 2020, your motion for continuance is denied. Matter, this trial is still set for October 7th. We will have pre-trial the
26th.
6th to 27th.
26th.
Pre-trial in this matter, or trial case management will still be set for September 26th at 9 a.m.
Judge, a couple of things. Number one, I have a full practice. I've got a docket day this afternoon in Santa Rosa County for Circuit Judge Scott Duncan. I've got 12 clients that are pending. I've got other people covering it, but I do have a full docket.
Sorry, you don't get to boo-hoo over your calendar. You took this case because you wanted money, fame, I don't know. You don't go boo-hooing now. You don't go boo-hooing saying, well, Judge, you need to look at my calendar because I have so much work. You had the same amount of work the day before you sent this piece of paper saying, I represent Sarah Boone. This one, homeboy, is on you.
If we set some of these hearings involving my motions, could I be allowed to hear my Zoom?
Any objection?
No, Your Honor.
The only request I would have, sir, is the rules of general practice require a notice regarding your appearance. If you could just file a motion and provide a form order, I'll sign it and you can appear virtually. There's no reason for you to drive all the way down from Santa Rosa County for all these hearings when we can appear virtually. JACS, I imagine, will be appearing virtually for some of these motions with regard to the experts. So as long as you file a notice in advance, sir, I've got no problems with that.
Judge.
Good day to you as well, Baddock.
That pre-trial order, it mentioned, I thought, that the state attorney was supposed to meet with the defendant and the defendant's investigator and review all the digital evidence from the order. That's the way I read it. They were supposed to sit there all together and watch every potential video exhibit the state was going to intend to introduce at trial. That has not happened. I think today was the deadline for that. I don't mind extending that because I'm going to need to look at the evidence.
With regard to the digital, the deadline, you are correct, sir. The deadline was today, based on the August 5 order. If it did not happen before then, as I outlined at the beginning, there was a change to that process. A thumb drive was provided in open court to Mr. Lang on August 9. He then provided it to Ms. Boone, a thumb drive of the specific digital evidence that the state is seeking to admit at trial, based on the witness and exhibit list that was filed under seal on August 9. Ms. Boone had the opportunity to review that information at that time.
All right, I'm going to ask for more time for me to review the digital exhibits they intend to introduce. I don't know if they've been redacted. I don't know if they're originals, but I'm going to need to look at that. I went to the jail yesterday. I had let them know in advance that I was coming. I believe my secretary had emailed them and said I wanted to bring in my laptop and my phone to view evidence and whatnot. I was not allowed to bring in my laptop and phone yesterday for 3.5 hours. So I didn't get done a lot of the things that I wanted to get done within that period of time. Probably would have stayed there a lot longer if I would have had that capability. So I would ask for some more time to be able to look, for me to look through the digital evidence as to what I assume it's being redacted. I know some of the audio in terms of clients' comments the client made, comments the officers made, some of it is, in my opinion, improper to be presented before the jury. So I'd like some extra time to be able to do that.
State.
what comments she made in the interview is improper. The 10 times she admits she did it, yeah, that's probably highly prejudicial, but she did say it. And what is she charged with? Second degree. Second degree. There's no premeditation they can prove, so it's second degree. And Mandy Strong, history and evidence shows that, contrary to Boone's claim, she is a sloppy drunk and abuser. She had complete control over Jorge and used 911 to punish him. Well, let's, as someone said, Jorge wasn't a saint either. Both of them were slap happy, and both of them had been to prison a lot of times for abusing each other. So it's just a toxic relationship with a lot of substance abuse that just went all the way to the end. So I don't buy her battered spouse, because we saw her, the way she acted. I played the 2 body cam videos from previous arrests. And what's that Ava Max song? Oh, she's hot but a psycho. Without the hot part.
I'm not certain, is he asking for a continuous again? What is the extra time that he's seeking?
What is it you're asking for? Extra time to do what?
The way I understand the order, I'm looking at paragraph 4 of the scheduling order and notice of hearings that, Judge, you signed August the 5th. Paragraph 4, the state's digital evidence will be reviewed with the state's investigator, the defendant's investigator, no later than September 3rd, 2024. This evidence viewing can be done in advance of September 3rd deadline. The state shall provide the defendant USB drive with station. They never viewed it with my client in its entirety. As the order states, they were to do by today. So the state attorney has failed to comply with the court's order. I'm saying I haven't had a chance to view it either. Can we reset that deadline?
Aaron, you missed a lawyer grasping for straws, a guy who probably figured out that this isn't going to earn him all the money he thought it would do, because he's really trying to get a continuance, and the judge just whacked him down, because this judge, as in every previous hearing, is 100% prepared.
On August 9th, Mr. Owens, we had a different hearing. And at that hearing, we addressed the digital discovery review. Mr. Lang was here. There was a USB provided in open court. And the August 9 order and notice of hearing identifies a change to that August 5 order. Specifically in paragraph 4, prison break investigations. By and through investigator Billy Lane shall take possession and custody of the USB jump drive, which contains the state's digital evidence, tendered in open court on August 9, 2024, and shall provide same to Major Malik X. Muhammad at the Orange County Jail today, August 9.
Case 1. This case can be over in 2 hours. They're going to play the body cam video from the house where she talks to the officers. Then they're going to show the interview, and then they're going to round up with the 2 videos of poor Jorge begging for his life. Then they're going to turn around, look at the jury, and says, "State rest." They don't need much more than that.
Paragraph 6, prison break investigation shall follow a court notice reflecting that the discovery in the USB jump drive, which contains the state digital evidence, was provided to Major Malik X. Muhammad at the Orange County Jail according to the date and time of the transfer. Such a notice was provided by Mr. Lane and filed in the court file. It was discussed at that August 9 hearing as to the revising of the digital evidence schedule. Paragraph 8 states that on August 14th, 2024, 1:30 p.m. A hearing will be held, courtroom 12A, regarding defendant's review of USB jump drive, which contains the state's digital evidence. The defendant's August 7th letter to the court, provided to the court on August 9, and the media's participation in the physical evidence viewing on September 3, 2024. Pertinent case law is attached. On August 14th, we had a hearing, we discussed that, and we identified that she had the deadline until August 23rd to make any objections. Now, under the original scheduling order, which said this matters, which on August 5, which set the schedule for when there would be deadlines for objections, those would be extended by good cause shown. Are you seeking at this point in time to extend the deadline for a period for objections which has since expired?
Yes.
Okay, state?
No.
Okay. How much time would you like, sir, in order to review the state's digital evidence that it seeks to admit into evidence and tender any objections?
I've got to go by jump drive. I've got to take it down to his office. He's going to give me that evidence. Obviously, I need to review it with my client. I've got a flight out of here around, I think, 4 o'clock. I don't know if I can get it done by then, but I don't see the necessity of an issue, maybe a week prior to trial, whatever that is, a week prior to that Monday, October the 7th, the week prior.
State?
I'm going to be amenable to setting a status hearing that week.
Here's what we're going to do. We'll address any objections to any of the discovery when we have trial case management on the 26th.
Thank you, Judge.
All right. Anything else, Attorney Jones?
Give me 1 minute.
Sure. State, anything else?
Not this time, Your Honor.
Madam Clerk is going to work dutifully to, it's already done? Excellent. I'll have Ms. Barrios, my judicial assistant, forward these to JCS and see if we can coordinate a hearing. State will have until close of business September 10th to file responses to motion for statement of particulars and motion for additional discovery. Parties have no other business before the court. You'll have a fabulous day.
Thank you, Judge.
Thanks, sir.
Can I have a word with Sarah?
Absolutely.
Am I free now? Am I free? Can I go home now? Are you gonna smile to me? Come on, smile to me, girl. Smile, girl, smile to me. Yeah, she looked at me. Did you all see that little side eye? Hey, some call you Broken Baker. I call you Buff Baker. Well, do we think that was a good start in front of this judge who we know is kind of by the books and sticking to deadlines? The judge, as always, was prepared, said, well, Sarah Boone, when she reviewed the evidence with the state, she was pro se, so you can't come claim that now. But we'll give you a copy and then you can review it on your own time. Yeah, she knew I was watching. Yeah, that, tomorrow we'll read on because I want to figure out if some girl will slap her across the face because she called them hair braiders. Have I been drinking? No, sadly not, because I would have been off the rails if I'd been drinking. And Squat Bob with another gifted membership, this time for Grass is Green Enough. Oh, grass is green enough. Well, then you don't have to go to the other side and look for it. He made a good effort, but it was things that has already been tried by the previous 4 lawyers. And as someone put in, yeah, they tried the DV, and the experts probably said it ain't gonna fly. And when they tried to tell her and say, "Hey, Sarah, it won't work. It's a stupid strategy," she probably flipped and said, "You don't listen to me because you don't." And we know how she is. We read those first 17 pages yesterday. What was it? 10 times in a row she got negative credit because she couldn't shut up in her bunk. This woman is incapable of listening to other people getting any information from anyone else, because she is the smartest person in every room she's ever been in her life. She wanted more time in the spotlight. No, I don't think she wants more time in the spotlight. I really, with the way she looked in the beginning, I think she thought this lawyer, and he probably blew a lot of smoke up in her derriere. But I think she believed him. Oh yeah, we're gonna go with the battered spouse again. Yeah, it's gonna be great. But we have all the previous arrests. We have all the problems going on at the house. We have her ex-husband who can talk about how she's a massive drunk and got into fights. There's the neighbor who wouldn't let her borrow the toilet, and then she ratted the boyfriend out, saying he was an elite. So again, what witnesses are they going to bring in here talking about Jorge was so bad? They have the body cam videos. If they're going to bring in that Jorge did all of this, the judge will have to rule if they open the door to bring in what Sarah did before. Because remember, both of them used to go to prison for DVing each other. Did he give it an extension to review evidence? Well, he said you can review the evidence and we'll see it. We'll see you back in court on the 26th. Sarah have reviewed it with the state, so ain't no way he's not moving any, unless she gets stabulated and goes to the infirmary or something like that. Trial will commence Monday, October 7th. This judge have said it. You have dragged this along for 3.5 years. We won't give another continuance without a super good reason. And attaining new counsel isn't a good enough reason. It's in the order that was given on, I believe, the 28th of July. It states directly, even obtaining new counsel won't get your trial delayed. Hey, Lefty on Rumble. She's like talking to a teenage girl. You don't hear me. You don't understand. Wah, wah, stump, stump. That's what I say when I see the way she acted in that video. Oh, the police is here. I need to give him a hug. I need to give him a hug. Oh, hey, oh, hey. She, I don't know. Her mom died when she was young. And I think she is mentally stunted at like 12, 14 years old. I really think she because we can read it in the inmate notes as well. She was giving a direct order, but she don't have to listen to anything. All the other people need to do what's been told to them, but not Sarah. Sarah is the golden goose. She's a straight A student. She excels at everything. Just if you didn't know. 16 times has this case been continued. 16. So what's 17 or 18 or 19? This judge will take it to court on the 7th of October. Her ad asks for a lawyer who wants notoriety, but he's been a lawyer since 86. Yes. And have her 100 cases gone through trial, and he has the worst website. Well, I've seen one that's worse because all of the recommendations on that website seem to be written by AI. But he has a picture where his wife is hugging him. I would never hire a lawyer like that. I want a lawyer who said, "You know that guy who stabulated 45 people, filmed it, and said I did it. I got him off the hook." That's the lawyer I want. I don't want a guy who's, "Oh, I play with my kids and my wife, and it's all so much fun." No, I want a guy who has the Hell's Angels on retainer. That's the guy I want because he knows how to do the law. In Rachel's opinion, her neuropsych evaluation will show one of a few things: substance abuse disorder, narcissistic and/or histrionic. Yes, it was clear from day one. People gave her too much grace at the start. Since the first day I saw her, I thought she was a blabbering idiot alcoholic. I have had someone close to me, my former teacher. She was not that bad, but when she was a little heavy in the drinky poo, she showed so many of the same signs. She wasn't violent or stuff like that, but that mood swing and the weird way they move, I could just see my my old teacher in her. I think she's flirting with that investigator, and he looked entirely uninterested. You never know. It could be me she's flirting with. And I've been single for a while, so maybe I'll kick that tuna can down the road. It's a miracle she needs, unless he can try the case in 1 week, maybe. Honestly, we've seen the evidence in this trial. We've seen the body cam for the previous engagements. We heard the husband on the body cam from the day off. We know the medical examiner saw bruising consistent with him being pushed down some stairs. At no point has anyone ever talked about how he used her as a piñata. It's always been they keep bailing each other out of prison because they keep fighting. They keep fighting. Battered spouse won't fly in this case. Absolutely no way, Jose. Hey, the heart wants what the heart wants. Sarah's insufferable. This attorney is in for it, but doesn't know it yet. Yeah, I thought you had a crush on Sarah Baker. I do. I just said I would rattle her tuna can. You just had to take one look at her skinny, malnourished alcoholic legs, and you knew she was a heavy drunkard. When she straddled that bush, yes, you could see that. And the way she, can I just get my Dr. Pepper? Can I get my Dr. I'm so thirsty. She had the worst cotton mouth. I'll bet you they were drinking white wine the day before. Cheap white wine, and the tannin just made her mouth feel like acid. Oh, I thought you weren't here, Zach. You've been cheating on me with Brandy Churchwell. So I thought if you can swing, so can I. Yeah, mutual toxic relationship. And again, as we see it in most self-defense cases, even the ones where I believe there was self-defense, as long as one part isn't breathing, it's a really hard hurdle to overcome. The media called it a Matlock miracle to the lawyer in the interview. Yeah, he's gonna find someone who can testify that Sarah actually wasn't on the address that night. She was in California or something. Don't because he's just gonna come here, and then don't tell Tom Gillis either. Hey, Becca and Little D. Wine hangover are bad, especially cheap white wine hangovers is some of the worst. I don't know if you have back in the good old days, we could get like a carton with 1 liter of wine, cheap white wine. It was It was grape flavored petroleum, but it was really cheap, and it had the alcohol. So the alcoholics just drank it because they don't care how it tastes. They just need the alcohol to fix their problem. And when I started drinking, I was a young paper boy, 13 years old. So we just bought what was cheap. And once we shared one of those boxes, it was so horrendous. Really, really, really bad. I would rather drink cheap apple cider. Really bad. I see another leather comment coming from Sarah. She was really writing. Yeah, she's gonna. Let's do a poll before we end the show. And we have a thunderstorm crawling in now. That's nice because it's been in the 80s today and it's really humid. Red wine in a box is the worst. Well, today you can get pretty good wine in a box. Back then it was what you couldn't sell or in the cheapest bottle you'll put in that. It was really bad. Wine has methanol. Don't drink it. Just drink this distillers instead. No methanol hangover. Aldi blueberry wine in the US is chef's kiss. We used to have Aldi had a bottle of like an apple snaps, and it was horrendous. But if you chucked it in the freezer for 4 or 5 hours, it was drinkable. But other than that, it was really bad. And you had the worst hangovers the day after. Yeah, I know. Boone Farms. Well, Let's Go Brandon is always saying it's horrendous, but did he bring any when I was in Tennessee? No, he hid. Thank you, Squabby, for another membership to Crystal DeSaro. Yes, DeSaro. You are most generous, good sir. New defense. Sarah's long-lost evil twin committed the crime. Yeah. Like Thunderbird or Boone's Family Farm here in the States. Ugh. Yeah, the 90s and 2000 wine in a box. That was evil. Yeah, but that was back when it just started. And before every household in Denmark, in middle class household, in my parents' generation, had a box of cheap red and cheap white wines, so they could have a glass when they made dinner every night. And then they started upgrading the wine. I remember having a taste of some of it when they had that. I was so horrendously bad, and it just draws all the moisture out of your mouth. It's the sulfates in wine that give you a headache. Okay. Your Aldi don't sell booze. That's another thing that's kind of weird coming to America. Living in America is you can't buy alcohol everywhere. When I was driving with Valhalla and we had to go to a gas station to buy beer, every supermarket, every gas station, every big convenience store sells alcohol. It's just, I don't know. It's a different culture, but it's kind of weird that you have to go to a gas station to get alcohol. Because if you buy beer at a gas station, it's because you forgot to buy beer for your party because it's so expensive compared to it. Yeah, you can get the good ones now. Bottles and James wine coolers. Don't knock wine in a box. You can't drink, Dave. So, no, because I got a strike for sharing something from a court feed from a TV station. So if this one has put one of those claims on it, I will lose the ability to stream for 7 days, so I won't play that. Living with a hernia. Yeah, it's a better one. I think she was smirking at the detective because he probably told her that she wouldn't find an attorney, and now she has one. No, that was L'amour. You could see it when she in the beginning. Sarah has been a naughty girl, and I'm just sitting on behalf of men everywhere. We're sorry, ladies. We can't help ourselves. Even Sarah can't get the tuna can rattled if she wants to. We are that basic. See you, Michelle Dunn. Have a great day. Yeah, well, when I was young, shops didn't have open on Sundays. We had like mini markets that had open, but everything was twice as expensive. It's different, not just in every state; it's every county. No hard liquor sales on Sundays in your county. Wine in plastic bags? No thanks. I don't drink much wine. See you later, Erin, Olivia. If you're going, I might as well end the show. But yeah. I need to get a Zoom link to bypass. It's not LNC. It's Sinclair Group who put a claim on the pool feed in Utah. Utah's law says you have to provide the pool feed to everyone. And Google said, yeah, we don't care. I asked the Google rep, said, so even though it's breaking the law, you upheld this? Yeah. We don't do copyright infringements. I said, I don't have a copyright infringement. I have a third-party content infringement. You have to remove your copyright. Can I talk to your manager? I got to the second manager. What's my favorite pastry? It's a Danish with vanilla cream and white frosting. I have a picture of it on my community page, which remind me I need to put my Discord link for this week in my community page as well. It looks like the horrendous cream cheese Danishes Americans make, but this is with vanilla cream, and it's la bombe. We only have tiny parts of the store open on Sunday. The politicians made a strange rule about square meters when they decided to have Sunday open stores. It's very strange. We have everything open on Sundays. I went and bought a new keyboard in our electronic store Sunday. That's ain't no problem in that. So everything, even if you go downtown to the shopping streets, they'll no Sundays they will be off still, but everything else, big retail stores open Sunday normal hours from 10 to 5. Yes, she did email me back. They will use it and when they contact Google and say, "Hey, look at this." That's the latest thing I got back. So I don't know. Marissa have also tried to get an intern fired at Sinclair Group, and then she got a generic email address. If anything comes of it, I need to get a license, blah blah, so I can send that to YouTube and they will remove it. I need to get something saying I'm licensed to show it because they put an illegal license claim on a court feed, which they couldn't do. But YouTube don't care. Not gonna last here either, Nanya, but I'ma enjoy it while it's cooler. Oh, I thought, have we scared you away? I don't know the guy, but it's stupid. Put a flock of squat bobs on a YouTube dartboard, spot a blindfold and throw. You're bound to hit me for at least another week and a half. I don't want to hit you with a dartboard. Yeah, that's how it used to be in Denmark too. But like the big stores, will have on Saturdays. Most of them will be 6 or 8 in the evening. They will close, and a lot of them, like the smaller stores, will have normal from 8 to 10, 8 in the morning to 10 in the evening, or 8 in the evening on Sundays too. So that time where you had to run to get that gallon of milk, we don't have that anymore. It wasn't so fun because I used to work in or in convenience stores as a baker, so we will always had the Sunday off, and then they opened on Sundays. That wasn't my favorite thing. Why did her boyfriend not try to take his finger and unzip the suitcase from the inside? I have just been thinking about that. Let's get Mr. Bender. I don't know if I can manipulate him enough to get him into. I can't get him into a full fetal position, but let's say he is something like this inside the suitcase. He can't move his arms. That's why he unalived. It wasn't because he couldn't breathe. It's because of the asphyxiation that he can't get enough CO2 out of the body when he breathes out. So it stays in the system, because the more he's squished up, the less the system works. So he can't detoxify his bloodstream, because as we all know from biology, you get O2 in, it goes through the lung system into the into the blood system, goes around the lungs, the heart, the brain, and then out through the lungs again, where it deposits CO2 because it picks up carbon. And if you are scrunched up like that and you can't breathe, so you're always doing this breathing because you are closed up, and he's probably panicking when he starts to feel, I can't get out of here. So I haven't seen the coroner report, but it's probably more liking to a carbon monoxide poisoning than a strangulation. It's because he can't move. He's fixed inside the body, so he can't get his arms up here and open, and he will be in a biomechanical position, so he couldn't even probably couldn't even get his arms out, because if he's fixed like this, there's no way he can get enough force to try and bust the zipper open, because it's the same. To be in a suitcase, he would have had to have had his legs in a position like that, and it's really hard to generate force if you're situated like this. If your legs is up here and the thing you're moving is right here, and you can't really force it. So that's why he didn't get out of there. He's in such a locked position. There's no way he can generate enough force. Especially, he was a small guy, and a suitcase can hold. Just see how they throw them around in the airport. So that's the reason why he died. Most likely because he couldn't exhume enough CO2, so he slowly became unconscious, and it's one of the good ways to go. You just fall asleep. He did try and get out. It wasn't lack of oxygen, though. It was a positional thing. Yeah, but that's because your lungs can't move. Then you can't get it out. So yeah, and he was drunk. Nope, nothing like that. Yeah, his lungs is compressed because he has everything is up against everything. So he can't expand his chest either. So he can't say and get all the air down in the lungs. He will probably be like, and he's in a confined space. His lungs isn't working correctly. He's under pressure, and he can't exhume all the necessary air. He could breathe, yes, but still, when you are in this position and you can't, it doesn't really matter because you can't clean your blood. Your blood go through the lungs to deposit CO2 and put in O2. And if you are shallow breathing all the time, just what what do people do when they get a panic attack? They breathe into a bag. Why? Because the CO2 will then be put back into your system and it'll slow you down because it's a gas. That's why people use a car to. So it's probably a contributing factor that he is squished up. His body can't move. His lungs can't expand, so he can't clean his system for toxins. Oh, yeah, we never heard about that suitcase. Yeah. Oh, it's thundering now. And he was also drunk as a coot. He probably passed out, and then, well, we know. Yeah. Yes, and purple is that's kids, close your ears. If you find someone who has been sucking on a garden hose in a closed car, they will be purple as well. It's because you can't get all of those. It's just because it's mono dioxide in a car. It's CO2 in your system, but it repels oxygens because it fills up the space where the oxygen should be. So just think about it as like a can. Normally you'll have the CO2 level here, but if you can't, whenever you put in oxygen, you can't get CO2 out. It'll rise, and in the end, you can only get a little bit of oxygen into your lungs, and that's not enough to keep you going. But the CO2 will stay in there, and that's why you turn purple if you do stuff like that. But of ways to go, it's horrendous, all of that, and it shouldn't happen. But most of the time, you'll just fall asleep. But this guy, we know he was begging for his life. She thinks she was out. She thinks she has outsmarted the judge because she's wicked smart. She's an idiot. Let's just say that. I think she talked to this lawyer and he sold her the Brooklyn Bridge. And she thought, oh, it's going to be fantastic. I'm going to get out of here now because he's such a good lawyer. And he said, we're going to do the buttered spouse that you want to do. And we get a continuance to next year and everything's going to work, dear Sarah. Let's see what people believe with the poll. Will he last till trial? 55% says no, and 44% says yes. I voted he ain't gonna last because when she gets home to her cell tonight, she's gonna write an angry letter because he promised her and he was ineffective. So yeah, but everyone, that's the show for today. Tomorrow, if nothing else pops up, we will read a chunk of the next 58 pages of her inmate report because right now I need to take a shower. It's hot and humid. It's become moist o'clock here, and we have a thunderstorm rolling in. So I better get off Los Netos del Intos. I will see if I can get Jamie to join me tomorrow. She don't like me anymore, but it's okay. Sarah does. Squabby, thank you so much for all the memberships. Thank all of you for. I don't think that Sarah Boone administered CPR either. She was worried about her drink and cigarettes. Agreed, Baker. He promised Sarah Boone a broken bridge. Yes. No, she didn't do anything. You can hear it in her voice, because if you do CPR, again, those of you who didn't take a CPR class, and you've seen Brooklyn's Finest. 1, 2, 3. No, that's not how you do CPR. The first thing you do, you take Bender. And the first thing you do is take your palm. Well, I'm old school. I got it in the old way. I know you don't do it like this anymore. Then you measure out where's the bone, 3 fingers above that, and you slam a hand into it, hopefully softening the chest a bit, because then you'll have to violently push on the chest cavity, because the ribs kind of don't want to bend. That's why John O'Keefe had cracks in his sternum, because you want to punch the sternum so you get a little extra movement. That's how we learned it in the good and olden days. I don't know if they do it the same way anymore, but you have to really apply pressure, and that's why John O'Keefe was found with broken ribs. A lot of people understood that as it was from the car hit him, but it wasn't. It was on the front. It's from the CPR. You will most likely see some kind of bruising in the area as well, if he hasn't been, the circulatory system hasn't been shut down for too long, so it can't bruise because blood won't race there. But you will put a lot of force in there, and you can hear on her phone, yeah, I'm doing it. No, you are really straining yourself when you try to do it. So no way she did it. No way, Jose. She only did enough to make him gurgle, which made her shriek on the 911 call. The gurgling, probably when she opened the suitcase, his lungs emptied. It's one of those things that happens when, let's just say, you have a lot of sphincters in your body, because you have it in every capillary and every blood vessel in your body, because it opens and shuts down the system to push blood around. And you also have it other places. And all of those sphincters will, at some point, when you go, let go. Think about it. You also have sphincters in your lung to keep the air in until you wishes to push it out. They'll also let go, and it'll sound. That's why you have the death rattle. You have been dead. You're not alive. It's not, oh, he's going to say something. No, he's gone. So, yeah. But tomorrow at 9 a.m., if I don't find anything else, we will do Sarah Boone's inmate notes. I'm going to send